Good afternoon. My name is Philip Munoz. I'm the director of the Constitutional Studies program, the program that's hosting today's event. Thank you very much for joining us. Just a few announcements before I turn it over to David Wilkinson, the president of the Federalist Society. Today's event is co-sponsored by the Constitutional Studies program and the Federalist Society. As many of you know, we have a minor in Constitutional Studies here at Notre Dame. Any undergraduates interested in that minor, find Jen Smith way at the back after the event, and you'll see some information on the table as well. We're sponsoring another event next week. As you might know, we don't shy away from controversy. Next week's controversy is on immigration in the age of Trump. What should Catholic social thought, or how should Catholic social thought inform immigration policy? That's going to be next Thursday. This room, we're going to start at 12:30 on Thursday, and we have it's going to be a great debate. I think we're going to do it Lincoln Douglas style. We have Peter Casarella, a theology professor here at Notre Dame, and he's going to be debating his college roommate, Rusty Reno, the editor of First Things. So join us again next week. We'll have lunch at noon, and then the debate proper at 12:30. I also want to thank, in addition to David and the Federalist Society officers, my assistant, Jen Smith. She's probably trying to run away. Jen, as you might imagine, it's been a very busy few weeks for her. So would you join me in thanking her? The format for today's afternoon goes as follows. I'm going to introduce David in just a minute, and then he'll introduce our speakers. Our speakers will each present about 8 to 10 minutes on their reflections of our topic. Our question for the day is, are anti-discrimination laws essential to freedom or hostile to it? So they'll each give a brief opening statement. I'll go ahead and moderate a little discussion back and forth so they can respond to one another's points. And then David will moderate a Q&A, and obviously we want your involvement and participation. There'll be plenty of time for Q&A. As always, we'll look for student questions first. I have one apology to make, which is I'm going to have to leave because I have to dash to O'Hare, such as it is, to catch a flight. We're sponsoring a conference in New York tomorrow, so I will quietly escape. But David will moderate and close the session. David?
Well, thank you all for being here. Special thanks to Professor Munoz and the Constitutional Studies program. It's been quite a week. That's the case when the debate over whether you should be able to discriminate is the uncontroversial one at Notre Dame. The Federalist Society is a group of conservative and libertarian law students. We believe in individual freedom, traditional values, and the idea that judges ought to say what the law is as opposed to what they think it should be. We also believe that good ideas and truth flourishes in the open if we just come with open hearts and sincerity. So that's why we're so pleased to sponsor debates like this one. And we have two phenomenal panelists with us, both highly respected in the legal profession and around the United States. Matt Coles is a deputy legal director and director of the Center for Equality at the ACLU. During the 1980s, he successfully opposed several ballot measures aimed at quarantining people with HIV. He's also fought extensively for same-sex marriage. In fact, in 2005, he was one of the people who helped craft the LGBT plan to make gay marriage mainstream in the United States. It was very successful. He also teaches at the University of California, Hastings. Professor Epstein teaches law at both NYU and the University of Chicago, which means he's been racking up the frequent flyer miles. He's best known for his writing on classical liberalism and torts. In fact, he's the third most cited legal scholar of our time. When he votes, Professor Epstein rejects both major parties because, quote, they're both two members of the same statist party fighting over whose friends will get favors. So, thank you all for being here, and please join me in welcoming our two panelists, and I believe Professor Coles will go first, or Professor Epstein. Okay, thank you for being here.
microphones for work. My voice is a little bit hoarse, but I promise not to sing, so maybe you will forgive. The topic is the question of whether or not the anti-discrimination laws are helpful to or hostile to freedom, as I gather. And the answer to that question is both. In order to be able to explain why, what you have to do is to figure out how it is that you need to combine freedom of association with the principle of non-discrimination. Anybody who thinks that you can come to this particular topic and banish either of these two great ideas from the discourse misunderstands the nature of the problem. Generally speaking, when you look around, you will see that both of these principles have huge amounts of support. So the question then is how it is that you start to organize. For most of you, if you start to talk about the discrimination laws, what you will start to think about is how they apply in modern civil rights theory on matters of race, sex, national origin, sexual orientation, and all that. I am a trained Roman lawyer, which actually puts me in reasonably good order in this particular building. And the anti-discrimination laws actually start way back then, and they work themselves through the fabric of the English law before you get to the modern issues. And I want to explain to you why it is, if you understand something about that earlier debate, you can understand something about the modern discussions that are going on. Early law distinguished between two kinds of property. That which was private, or basically is you got it by possession and you could exclude everybody else. And then there were things known as the race commune, rivers and so forth, in which you could never privatize it, but everybody had to have equal access to an open resource, getting on the river, using it for navigation, transportation, fishing, or whatever. And you could see on the first part of this situation, it turns out that if you have the right to exclude, that means that you can figure out who's going to come in, which means that you're going to be able to engage in some degree of discrimination by some particular standard, because nobody would say about an ordinary person that he is a common carrier required to take all sorts of business. And rather than try to figure out externally what people ought to do, you give them their choices. And the way in which the markets equilibrate is as follows. There are many people who have private property. They have different preferences of one kind or another. Each of them can have different standards to who gets in and who gets out. And there's a kind of economic equilibrium and competition that takes place, which is if there's one group which a certain set of owners and proprietors don't want to admit, if there's open entry into the market, somebody else will serve that particular community because you'll get a higher rate of return serving people who are neglected and overlooked than you are by people who are amply served. Many people won't anticipate this in advance, and so you will rarely see these huge forces of imbalance. In these kinds of markets, what do you expect to see? Well, it's very difficult to predict how they're going to work on the private side. But you will have some things which may discriminate on certain grounds, maybe race, maybe sex, maybe age, and so forth. But as you have organizations that do that, you will have other organizations that have exactly the opposite kinds of preferences. And what they will do is make it a point to admit people of all different kinds of groups into the same situation. Most of us, when we actually organize our own lives, we tend to like both kinds of organizations. We may join same-sex teams on the one hand, but be involved in a whole variety of organizations in which we think that the only way we'll get good discourse or good education is to have people from all backgrounds coming into participating on even terms. And if that's the way in which the situation works, you'll have a natural lottery take place. Those organizations that are too exclusive will die. Those which understand whom to admit and how to treat them will tend to flourish. And what happens is there's a huge amount of redundancy built into the system because the mistakes on one leave people with lots of other choices by somebody else. So the precondition essentially for this working is there has to be free entry into a market and free exit for those organizations that fail. No subsidies of one kind or another. Now, with respect to the common resources, it's exactly the opposite. There is no substitute for the standard river. And as we start moving forward in time, there are two kinds of organizations which essentially are going to have universal duties of service. Well, one of those are your common carriers, and that would include various kinds of roads and railroads, and your public utilities like the electric company, the gas company, and so forth. The technical economic terms that describe them is they have natural monopolies in the sense that it is so costly to put up the second unit that you have to have one and only one unit. And going back as far as one could imagine to the 17th century, the rule was that if you have monopoly power as a common carrier or as a public utility, you have to take all comers on a non-discriminatory basis. You can charge them a fee sufficient to cover their costs, but you cannot discriminate against them by charging more to one group, independent, of course, because of their race, color, creed, or national origin. If it turns out that there's some powerful reason to impose some degree of segregation or separation in order to preserve order and so forth, you may be able to do that, but that's an extreme and a rare case. It's not the dominant solution. So if you're trying to figure out, do we or do we not believe in a non-discrimination law? Well, the answer is we believe in both. Freedom of association works well when competitive opportunities are available. Duties to serve become, on a non-discriminatory basis, required under those circumstances where there are no particular choices. The question then is, how does this carry over when you start to think about various issues associated with race and so forth? And I start more with race than with sex. It's not that the latter is unimportant, but certainly the dominant history and the great stain on America of segregation is something that one has to deal with and face powerfully. And the first thing one has to understand about it is that this was not an open or free economy. That is, given the pervasive power of segregationists in political office, the free entry condition associated with a healthy competitive market does not take place. Nobody who wanted to cater to black customers could open up freely in the South in 1930. They would be shut down by closing off their access to the public utilities in one form or another. So what you could do is you could devote yourself to creating a highly segregationist society. Somebody said, well, I mean, they could always leave. But one of the interesting features about the South is they did not want their black citizens to leave. In fact, they passed laws that made it illegal to help them to leave. And the reason is quite simple and quite ugly, is that this is the type of situation where if people can leave, you cannot exploit them. And so there was this huge migration going up to the north from about 1930 to about 1970 in an effort to escape this situation. So the original justifications for the civil rights law is you have to count as powerful Southern forces. And there's no question if you actually look at the way in which the economics played out in the decade between 1965 and 1975 is when you see the greatest progress taking place in eliminating black-white differentials. And that's because what you did is you dismantled the situation of the Southern monopoly and you created, through the application of the civil rights laws, more competitive markets than would otherwise have taken place. Now, if you start looking to the periods after that, what happens is the progress along these lines starts to slow because you no longer have to face the organized system of the state. And now the question is, how does the anti-discrimination law start to apply in those cases where markets are more competitive because the political conditions have changed and changed very rapidly? And here let me just sort of start with the following observation. I am unfortunately old enough to have lived through and accomplished all of the debates about the Civil Rights Act of 1964. And one of the great miscalculations associated with that particular rate was the firm conviction on the part of all of the supporters of 64 that what you had to do was to have a colorblind workplace in which you could not give preferences to one group or another. I'm sorry to say that if you had tried to put forward an affirmative action program as part of the statutory scheme in 1964, the act would have been defeated. It turns out that this was a colossal miscalculation. Eventually, we did get, through torturous reasoning in a case called Weber in 1979, a relatively clear path to doing that. But in the interim, the insistence on the colorblind rule meant that notwithstanding the huge amount of violence and dissatisfaction that had taken place in the United States, no private business could decide to engage in an affirmative action program without running afoul of the law. And so what happens is eventually we come to a very difficult situation in which the civil rights laws punish on rather dubious statistical grounds any disparate impact which seems to favor whites or males, and then tries to run affirmative action programs on a halting basis. The sensible thing to have done from the beginning was to follow the basic rule. If it turns out we're dealing with industries that are competitive, and that includes government offices that work in competitive markets, just allow things to sort themselves out. There will be some organizations which will go very heavily in favor of affirmative action programs, and you don't need to have subsidies. And then some of you will say, oh, but there'll be some businesses which will just exclude everybody on the grounds of race. And to which my answer is yes, and thank heavens. Because what you want to do is have a group of people who are virulent in their taste and impossible to work with, or let them organize themselves over there. And that means our ability to organize other organizations will be easier because we don't have to fight people who will essentially have a rearguard action on these kinds of issues. So, if you actually look at the type of situation, the old solutions, which essentially says wherever there is statutory power, which gives you a monopoly, you have correlative duties of service. But in those situations where open competition is available, we allow free choice to take place. What would happen is you would have a much more responsible employment market. The number of jobs that would be available would increase. The ability to use testing and other devices to sort people out would become much greater. And I think in the end what we would say, quite accurately, is that the overall level of growth for all citizens would do better under competition than under the situation with respect to the EEOC. Now, why is that? Well, in part because the fundamental plan is misguided, and in part because of the public choice difficulty. And I'll end on this note. There is nothing which says that because you have a noble objective to be enforced by various organizations, that when the administration of these statutes take place, it will be flawless. All of these statutes essentially are populated by individuals who have some kind of bias one way or another. And it is very difficult to take people who think that discrimination is the greatest evil on the globe and have them act with a relatively dispassionate sense. So that in Republican areas, you may have some degree of indifference. Democratic areas, you may have some degree of over-enthusiasm. But when you try to figure out the remedy that you're imposing, understand that the imperfect implications of administrative law are sufficiently serious that you have to be very, very careful before you're prepared to entrust that kind of power to any government agency. And it's quite clear that the huge battles that we've seen with the Office of Civil Rights as it applies to education and with the EEOC as it applies to labor have shown that, in fact, certain degrees of intolerance on the part of government officials can, in fact, be every bit as dangerous as private intolerance, with this key difference. You can't shake the government monopolist who runs the EEOC, the Office of Civil Rights. You can decide to go elsewhere if there's a private firm that acts in a crazy way. I have been an administrator in private firms, and I can assure you, if you wanted to go forward and put forward a strong kind of racist and segregationist program, you last an hour or less. The biases and the pressures in mainstream institutions are in the opposite direction. And it's precisely because these pressures are so strong and these tastes are so well formed that you do not need the state clobbering you over the head with a set of rules, which mean that outsiders who don't understand the internal trade-offs that have to be made to keeping an institution sound and solid in terms of its composition of its student body, or its faculty, or its administration. These people from the outside hammer on only one thing. Any administrator constantly is looking at all of the trade-offs. In the end, decentralization and privatization of this solution will lead you to better answers if you follow the same principles on discrimination in private competitive markets and open access and monopoly markets, which characterized the earlier World War. And on that note, back.
Well, thank you, and thank you very much for inviting me here to Notre Dame for three reasons. I've long been an admirer of Richard Epstein's work. The depth and breadth of his intellectual take is really astonishing. Second, I had just a fabulous time last night with Professor Munoz's class, and it is one of the warmest welcomes anywhere I've ever had, and I'm very grateful to Notre Dame for that. And finally, my mother's family is pleased. In my mother's family, there were two institutions at the pinnacle of higher learning, Notre Dame, of course, and then after my father joined the family, somewhat grudgingly, Yale was allowed in as well. I finally managed to get to the pinnacle of higher education, and even if just as a guest speaker, I'm grateful for the invitation. For those of you who were hoping, I think, today to hear a continuation of the the 25-year scholarly debate about this subject, you may be in for a little bit of a disappointment. I'm not a scholar, although I'm a professor at the University of California now. I practiced law for 40 years until this August, the last 30 years with the American Civil Liberties Union. And so the perspective that I bring to this is what I would call the perspective of a constitutional practitioner. And I think it's very different than Richard's. It will lead us definitely to some common ground, but I think will also lead us to some ground for some fruitful conversation. I start thinking about civil rights laws in a somewhat different place than Richard does. I start thinking about the American experience that I did. And look, let's not kid around about it. The genesis of the civil rights laws is that our forebears went across the ocean, captured human beings, transported them back across the ocean, and put them into bondage. Bondage where they were treated like beasts, and the question of rights was not on the table because they weren't regarded as human. And that original sin, I am sorry to say, was acknowledged in a document that many of us here revere, and that's been the source of my professional practice, the United States Constitution. At the end of the Civil War, we amended that Constitution to begin the process of undoing the greatest wrong in our heritage. And I want to focus on one aspect of the 3 constitutional amendments we passed in order to begin undoing that wrong. Now, at the time we passed those amendments, every state had, as it has today, a system of laws that organize our ability to carry on in civil society and protect our ability to be participants in civil society. The laws of contract, the laws of torts, the criminal law, laws about access to the courts, laws about access to self-government, the right to vote, and related rights. The magnificent part, I think, of there are many magnificent parts of the 14th Amendment, is its last clause, which guarantees that no state shall deny any person the equal protection of the laws. And I take that to mean that those legal structures that we create to organize civil life, that the aim of the Equal Protection Clause was to say everyone's going to be able to participate equally in the system now. Everyone's going to have their lives structured and protected, their commercial lives, by those bodies of law and their day-to-day lives. And that's the great promise of the Equal Protection Clause. And that Equal Protection Clause, it doesn't just state an aspiration, it puts an obligation on our states. It says that states shall not deny equal protection of the laws, and if states fail to do it, it gives Congress explicitly the power to step in and make sure that state laws do provide equal protection. So, almost 100 years after we've amended the Constitution to change the structure and make that promise, we are basically nowhere. Black people in America, by and large, have at best access to a third-rate education, and in many places, no access to education at all. Black people are treated shockingly in both civil and criminal courts, and I'm talking about the early to the mid-60s. And as for self-governance, well, nowhere in the country are African Americans full participants in the process of self-governance, and in much of the South and the Middle West, they're not really participating in it at all. And that's the genus of the federal civil rights laws. They're an attempt to step in and make up for the failure of the states to discharge their obligation under the 14th Amendment and ensure that the legal structures we have are protecting people equally. So it's fair to ask, I suppose, that was in the mid-60s. It's now 2017. Are we there yet? Have they worked? Or have we kept the promise of the Equal Protection Clause? And I think the answer to that, if you just look around, is pretty clearly no. Yep. Look at the financial crisis of 2008. Most Americans were hurt by the financial collapse in 2008. But no one was hurt as badly as African Americans were. Most wealth in the African American community was in people's homes, and a huge proportion of that population lost their homes. Now, you could look at that as just a disparate impact because so much of the wealth was held in homes. But you look across the board, and African Americans with similar qualifications were consistently given loans that were going to be much, much tougher to maintain and service. There's no question of that. Look at stop and frisk in New York, and New York City, holding all other variables constant. It is very clear that you have a far higher chance of being stopped by a police officer and searched for no real cause if you're black. Test after test after test to employers show that when an employer sees indicators on a job application that make them think that people are black, people with the same qualifications don't get called in for interviews. Now, there are methodological objections to almost all of these tests, but I will tell you, as social scientists have said to me, when you keep testing in lots of different ways and you keep getting the same answer back, reality is trying to tell you something. And I submit to you that in the situation in which the 14th Amendment was passed, and in the situation that existed in the 1960s when we passed the Civil Rights Laws, the notion that people living on the wrong end of that inequality were making choices about personal freedom is illusory. There is no personal freedom if you don't have access to the system. There is no personal freedom if the laws we've set up to organize day-to-day life don't protect people equally. So what about LGBT people? It's been alluded to. I mean, LGBT people weren't sold into bondage. We didn't fight a civil war over it and amend the Constitution over it. No, but when we adopted the 14th Amendment in its first drafts, we made it explicitly applicable to race, and we made a decision that we wanted to do something differently. And the 14th Amendment guarantees equal protection to any person. So the question really is, has the case been made, or is the case being made, that LGBT people deserve treatment from non-discrimination laws as well? And I submit to you, based on what we know, the answer is pretty strongly yes. Now, there's a fair amount of academic writing about discrimination based on sexual orientation and its extent. I have to say I'm not entirely trustful of it, although again, I'm not a scholar. But the practical tests that I've seen run on housing discrimination and job discrimination are pretty shocking. And in many ways, I think more important, look, we're talking about a group of people for whom we're told from the very beginning of their lives, because it was a central tenet of society, that it is impossible for you to actually have a fulfilling life, that you are incapable of the kind of emotional commitment and bonding that's central to having a fulfilling life. And I say to you that when that is as powerful a cultural message as it was, personal freedom is largely an illusion as well. Now, when you ask the question, should we then continue to have civil rights laws, part of the disagreement I think that Richard and I have is what's the best way to achieve a society in which the promise of equality is realized. But I don't think that's all of the disagreement. I think, based on what I've seen in my experience, that the prejudice that excludes, that keeps people out of the system, that means that the system doesn't really give them a fair chance, is far more pervasive. It's not an occasional thing. It's not one firm or another. I think African American people, particularly younger African American men, leave home every day in fear that they will get stopped for no reason whatsoever, in fear that they will get searched for no reason whatsoever, and knowing, because we see it again and again and again, that people who get in those situations far too frequently wind up dead. It's not that what happens to you if you're not equally protected by the law is an insult. It's not something that you can get over because it's just a dignitarian or an emotional crime. It's a real exclusion from equal participation in our society. I don't think personal freedom of choice means very much until we've kept the promise of equal protection. Thank you.
Thank you very much. A question to both of you, which is what you perceive as the essential disagreement with one another. Can you summarize that very easily for people?
Well, I can give you, is this thing working?
Yeah.
I think that a lot of the differences was twofold. One is we were talking about different topics. I was talking about the anti-discrimination laws as they apply to employment and to education, and Matt was talking about the sort of larger system and culture having to do with everything from the criminal law and the law. And let me see, that's what it is. The other difference, I think, which is very powerful, is how do we figure out the rate of progress, if any, with respect to race relations in the United States in the last 64, say the last 30, 60, 40 years, 50 years. And we have very different views on that. Let me just give you what I think to be the single best measure of social advancement of any particular group, which was not mentioned by Matt, but which I think is A, measurable and B, extremely important. And that's the difference in life expectancy and birth as a function of race. Okay? So you go back to 1900 and you figure out what those numbers are. And they're quite amazing. It turns out that the white figure is around 47, 48 years of age, and the black figure is around 31 to 32 years of age. It doesn't take a genius to realize that something very heavy is pushing on that. You then fast forward to today, and that gap is down to about 3 or 4 years. And most of that difference can be explained in a higher rate of death amongst black teenage males between 15 and 30. How do you get a situation in which you get this massive transformation? Well, you can't say it's the top 1% that gets it all. It's not as though we have a bunch of people who live 900 years and everybody who doesn't agree. It has to be that there's some widespread social transformation which has made all of this possible. And so at this particular point, to assume that nothing has changed when the single most important measure has changed is, I think, incorrect. Now, what are the changes that we start to look to? Well, some of them I think are perfectly benevolent. Is that huge amounts of this is because of the improvement in basic public goods, the control of infectious diseases and so forth. And the interesting thing is that these are always public goods, and the biggest bigot in the world can't figure out a way to make the water supply safe for himself and leave it dangerous for everybody else who shares a common system. So this is a huge upward pressure on the way in which these things work. And then there's the question about access to the political system. If you go back and you read the Section 5 disputes, it's pretty clear in 1964, systematic exclusion from the polls was a device in which you could enforce rigid segregation laws in the South. Well, at this particular point, notwithstanding whatever quarrels you have about the way in which the laws are administered, the black participation rate in the United States is at least as high on voting as the white participation rate, and in many cases turns out to be a lot higher. So if you change the political base of the power, it's going to completely change the way in which these other social institutions start to work. If you look at universities and so forth, you could find the occasional person who spouts hatred of one kind or another. But I think it's a real insult to the thousands upon thousands of people who have worked very hard on this question of racial injustice and historical prejudice in an effort to try to create open environment. I do not know of a single major American university or public institution which is not committed to some form of program. In fact, today, I think the dominant rubric is called diversity and inclusion. That doesn't strike me as a label for white privilege, and I think it has completely transformed the way in which these various sorts of institutions start to operate. So, I mean, you can certainly look to differences, but you have to understand it. Let me mention one other, the criminal situation and stop and frisk. The interesting thing is Terry versus Ohio, which was the case which legitimated stop and frisk, was a decision by none other than Earl Warren, supported by none other than John Marshall Harlan, two of the, shall we say, sagest people on civil rights laws that you can do. And they were very uncomfortable about the decision, but they thought it was appropriate. Matt starts to talk about the differential access situation, but let me mention a couple of other statistics. that may slow you down a little bit is the first thing you have to do is to take into account the underlying difference in the criminal rates. And the probability of a black man versus a white man in New York City committing a crime today differs by an order of about 40 to 50. If you then take that and check it against the stop rate, the probability of stopping a black person relative to the base is actually lower than it is for stopping a white person. And the failure to enforce some of these laws in places like Chicago has led to a huge increase on black crime. The best estimates are in Chicago, 1,000 excess deaths have taken place since the ACLU, you've heard of that organization.
I have.
Yeah, negotiated an anti-stop and frisk campaign for the Chicago police that has put the city into paroxysm. So it's of course correct that police do abuse things. It is of course correct that they be punished when they do so. But one has to understand that this is a larger question with multiple implications, and base rates really matter on these particular numbers. So I think that's the second one. And the third is, what is the promise of equal protection? I'm going to just give two cases which I think it shattered shattered the promise of the civil rights laws in the period between 1865 and 1900, from which we're still recovering. Well, the first is Slaughterhouse, which essentially said privileges and immunities, which was the key to citizens, was essentially read out of the Constitution by a bunch of judges who did not want the federal government and Congress to be a perpetual censor over the state. The second is a case called Cruikshank, which in 1875 said that if it turns out that the way in which the white supremacists managed to get power into the state of Louisiana was to murder their black opposition, the only place where you can try them criminally would be in the very courts that they established by their behavior, which was a complete negation of the promise. And the third was the big government promise of Plessy v. Ferguson, which in one fell swoop said that the police power, the antithesis of individual liberty, required segregation in schools, required anti-miscegenation laws, and required separation of races on the common carrier, all of which are opposed to classical liberal principle. And that failure to get things right in the immediate post-Civil War period is in fact the source of much of our problem. And folks like myself have attacked them with every bone and fiber in favor of smaller government under these issues. And it's not as though that will rectify all the past harms, but at least it gives you a chance to make things better than they otherwise would have been.
Professor Coles, one sentence on the differences?
One sentence. Well, take equal time.
Well, I think that Richard's explanation shows at least two areas where we do agree. Again, one, I agree with you on all three of those cases. They were wrongly decided, and they've created huge problems. And I did not mean to say that nothing has changed since 1870. Lots of things have changed since 1870. I simply meant to say we're not there yet. We're not even close to there yet. Three quick points, and then I think to the core of the difference. What you say about life expectancy, I think that's great. I think that's terrific. I don't have the statistics at my fingertips. I just don't think it's a complete answer to the problem. It's good that people are living longer, and that is an important measure. But I don't think that tells us that there's not discrimination at the retail level. Not only not discrimination at the retail level, but pervasive discrimination at the retail level. You know, the voting participation, I love that. This is exactly what a judge in North Carolina said to us after the state legislature went through all the devices that exist to make voting easy and got rid of every single one that was used disproportionately by African Americans and kept the only one that's disproportionately used by white people. And what did the trial judge say? Yeah, but black people turned out to vote anyway. The message being, if people throw obstacles at your ability to self-govern and you overcome them, then you're not entitled to be protected by the law anymore. I think that's wrong. You do a process like that legislature did, and it needs to be undone. You don't select things out that way. I don't think that the answer to lawless behavior is more lawless behavior. And if the police department of the city of Chicago is phoning it in, that's a big problem. But the answer to that is not to say you get to do open season again, things are over.
Finally, look, I think the real difference between Richard and I is this. Richard, I think, has an abiding faith that a market economy left to its own will correct this problem and things will right themselves. I don't have that faith, but I think part of the difference in view has to do largely with my sense that the problem is much larger and more pervasive than Richard thinks it is. And I think even for somebody who believes markets will correct those things, when the prejudice, the exclusionary attitudes are as pervasive and as strong as they are, it's not really possible to go down the street to the next firm and get the job.
Richard, would you respond to the point on culture, prejudice, and
Yeah, I mean,
do you agree with you?
no, I think in effect, if you actually check racial attitudes in the United States today, there's a marked transformation from what they were when I was a child. If you look at all the private institutions and see how many of them have been opposed to various kinds of affirmative action programs, diversity programs, and so forth, they have virtually none. I think the private response has been much more powerful than the public response. Look at the areas in which you start talking about finding failures. You're talking about the police department. Last I looked, we do not have a market system with respect to the police department. They are government monopolies, and like all government monopolies, they have to be watched. But like this particular government monopoly also turns out to be somewhat indispensable. If you look at voting, that's not a market system. That's also a government monopoly. But again, what you have to do is to say this. The North Carolina case is actually, I think, a little bit closer than Matt talks about. There was some justifications that were neutral and independent. But let's suppose he's 100% right. That's 100% right. You're talking about essentially a marginal gain, which would be relatively small, not that you don't want to look at. The huge gains were those which were achieved after the transformation of the 1965 Voting Rights Act. And nobody, I think, wants to go back on that particular situation. And this is the difficulty that you always have with public remediation. Your problems get a little bit smaller because you've had so much success. And the remedial structure that you have to put into place becomes much more complicated. And so you may not like what they did in North Carolina, but it's identical to the rules that are now in places in states like Connecticut, where this doesn't happen. The 64 Act assumed that there were certain states that were beyond reprieve and they had to be specially monitored. It's been all transformed since then. So if you get to the Voting Rights Act of 2007, this is what you see. You see a longer and more draconian system based on the 1964 distributions, not on any update, for a problem which is much different from its original situation. Now, why do we get that? Because there was no other way to get the extension of the Voting Rights Act through the political nightmare associated with Congress. And when Justice Roberts said, you're going way over on Section 5, well, what did he mean? Is you don't have racial discrimination in terms of the way in which you vote for a Public Utility Commission board, which was set up 30 years afterwards, and which there's been no evidence of discrimination. So in addition to going after the bad guys, and I'm with Matt on that, overbreadth in enforcement of these statutes is a very serious issue, and you have to figure out whether or not on the remedial side you've gone too far or whether you've not gone far enough. But in terms of universities, I will tell you, working in there, you really want to find a group which is always on the defensive. Try us classical liberals. We manage at a place like Notre Dame, as a relatively conservative institution, to be 5 to 10% of the faculty, right? And everybody else is on the other side. When I think about my alma mater, Yale, oh my God. I mean, with Peter Salovey, you can't get a conservative to speak or to join it. The law school faculty probably has 4 or 5 out of 50 on this stuff. If you're worried about imbalances, I'm not excluded. I'm too old to be excluded. That's my great comparative advantage on these things. But I can assure you, when I try to place younger people who are in the classical liberal tradition, you often meet a huge buzzsaw of resistance from established parties. And I think that that is wrong as well. If you want to talk about diversity, add an intellectual diversity, please. I can't get people to join my center because I can't promise them as young scholars that I can place them. That's how powerful the political preferences turn out to be. This is a very serious problem. I hope that Matt would agree with me that we're better off with a balanced intellectual community. I don't regard myself as a troglodyte on many of these issues. I think I have a very different framework. But you know, it's nice to have a Roman lawyer talk about some of these modern issues because it's a voice that you're not going to get by people who are not trained in that part of the discipline.
Professor, well, I'm going to invite you to respond to this, but can I frame it with a question?
Sure, I don't promise to stay with your friend, but
That's all right. He's a great lawyer, by the way. And he knows when to duck a question, as do I.
One of the differences I see between the two of you already is that you think law really needs to help influence culture. Yes. Law really needs to target prejudice. Does that mean if you're successful, if the ACLU is successful, at some point in time, we won't need anti-discrimination law? Is that the goal?
Not going to happen.
a couple of things. First, I completely agree with you about intellectual diversity. I meant what I said at the start. No one has read all of Richard Epstein's stuff, but I've read and assigned a fair amount of it, and your thinking has helped me develop mine that hasn't entirely gone along the same line. I hope I'm not too much of a disappointment.
No. Par for the course, as we say.
On stop and frisk, go read Floyd against New York. I think I'm right that when you control for all variables, it is still wildly disproportionate that black men get stopped. On racial attitudes, I think that's a more complicated question than Professor Epstein thinks. Do I think they're better than they were 40, 50, 60 years ago? Sure. I used to do voir dire. We don't do voir dire very much anymore, but I used to do it and I used to teach it to both judges and lawyers. And voir dire is the process by which you question prospective jurors to try and find out whether they've got a prejudice against your case. And as I said to a convocation of Supreme Court judges in New York a few years back, I can almost always get somebody in voir dire for prejudice based on sexual orientation, for prejudice based on religion, and much of the time for prejudice based on gender. I can't get people for prejudice based on race anymore. I just can't do it. And this is a good 15 years ago. They said, why not? And I said, because everybody knows what you're supposed to say. And nobody says anything that they know is that far out of the cultural scheme. So my point only being, yes, things are better, but also some of the pervasive prejudice has gone underground. And I still think when you look for the outward manifestations of it, it's there. Let me say a final word about anti-discrimination law and why I think it's important. Do I hope that ultimately they are unnecessary? I do, and I think I have maybe a little more faith in the capacity of attitudes to change even than Richard does. I think the scope of change on race, on gender, come on. For those of you who are back in our era, you went into a law firm in 1967 and there were plenty of women there. They were all secretaries. There were no women in power positions in law firms in the 60s. Have things changed? You bet they've changed. And I think a big part of it is look, law doesn't work because you haul people into court and hold them to account when they violate it. We do that. We do that in the criminal law and we do that in the civil law. But the reason law works is because law, I believe, is a society's statement of its aspirations of what it wants to be like. And most people conform their conduct to what the law dictates. And when we look at those attitudinal changes, which I agree with you are there, I think part and parcel of the reason they're there is the 1964 Civil Rights Act.
I think that's actually very complicated because the history goes in both directions. You would not have gotten the 1964 Civil Rights Act unless and until you had a change in racial attitudes on these subjects. Everybody's least favorite author is Charles Murray. But let me just mention one of the findings. Charles is a good friend and an admirable human being. And one of his findings that's most interesting is to ask yourself, if you put a dummy variable in for race, and then put all the other situations, when do you find essential equality based upon education and so forth? Charles's conclusion was that happened in 1963. Very counterintuitive to most people. There are obviously things that have happened. But there was a huge change in attitude. Let me just mention a couple of the things that led up to the Civil Rights Act that made it possible. One of them is Jackie Robinson. This may seem like a small thing to you, but for some kid like me who grew up in Brooklyn in the late 1940s, this was huge. Then there's Harry Truman, who essentially basically entered an executive order in July of 1948, abolishing racial segregation in the United States military. If you had tried to do that in 1941, you would have had a race riot on your hands, and everybody kind of knew it. Then there were people like Marian Anderson. God bless Eleanor Roosevelt on this, because when your DAR wouldn't let him sing, she had to sing on the steps of the Jefferson Monument or so forth. She fought for the
Lincoln Memorial.
Lincoln Memorial. Well, different place, same idea. There were just huge transformations. States like New Jersey had segregated rules until 1947. The University of Chicago hospitals and laboratory schools were only integrated in the immediate post-war years. I mean, one has to understand that there was a lot of stuff that was going on in these earlier periods. And at the time of the Civil Rights Act, everybody I knew, myself included, was in favor of them because we saw the phalanx existing in the South and had to break it up. The question is, what's its durability? I'm just going to go to the labor stuff for a second. Essentially, the only positive impacts that you can find from these rules by people who were strongly in favor of them, Jim Heckman and John Donahue, the two leading fellows, end around 1975, 1976. Because that's the time at which systematic discrimination was essentially removed. One has to sort of know this kind of history. Now, let's see other features. Now, let me give you one statistic about labor markets, and then you make of it what you will. Law schools now are about 50% female. NYU is 55% female in the first year class. It turns out, if you look at entry levels in the firms, the major firms, it's basically maybe not 55, but 50, 52, equal number of women. You look at the partnership level, and it's 85-15 male at the major firms. The question you have to ask yourself is what's driving that? And there are two very different accounts. One is that the firms kind of actively discriminate against, and the other is the women actively, more so than men, peel off to smaller firms, in-house counsel, get married, give it up, whatever it is. And as best I can tell, having worked in this market pretty well, if you look at the programs, what is most characteristic about the major firms is they do not regard compliance with the Civil Rights Act on sex discrimination as sufficient for their recruitment policies. They're giving all sorts of benefits, child care, extra leave, you name it, they're willing to provide it. And one of the things that you have to deal with cultural attitudes is to remember they don't only come from the top, come up from the bottom. And it's not that they're collective. So you will find many people who will say, gee, I want more women to be in the workforce at top positions, and I don't want to be that woman. And this is, I think, the problem. I'm going to state it very bluntly. I think on the workplace issue, where I don't think ancient prejudice is harbored, you try to work for a firm, a large law firm, and announce that you don't want women in your firm, or blacks, you get fired. Years ago, we had the Baker and McKenzie case at the University of Chicago. I just want to tell you an anecdote. I won't name the woman. She was a wonderful person. She goes and she interviews at Baker and McKenzie. And one of the partners there is kind of tough on her. This is 1991 or so. And he says, well, why do you want to join a place like this? You know, you could join a black firm. You could join a black country club. The Jews have their own country club. All of this stuff. And what happens is, she goes back to her friends and she says, I got a bunch of jobs. What am I supposed to do about these jobs? And they said, you should write a letter. Well, I was sitting at the faculty round table and I had two friends, one of whom was an ardent defender of the Civil Rights Act, and the other was somebody who was somewhat skeptical of it. And we had to have a prediction. And my civil rights friend, strong guy, said, the firm will file and forget it in the waste paper basket. And the other guy said, the shit will hit the fan. That's a quote. Pardon my French. And that's exactly what happened. This guy was out of the firm within a matter of a week by a 90% vote. The firm came to the University of Chicago and said, please sanction us. And then, just to get it better, one of our law students said, hey, we got a great civil rights case here. Why don't we sue under Title VII? Well, they looked at it. What had happened? The guy who had asked the question had actually voted for her to get an offer. The firm had extended an offer. There was no violation of Title VII because there was no refusal to deal. What does it tell you? The reputational stuff was unbelievable. I cannot begin to describe it to you. And the lawsuit was zero. And now what you do is you go to the Harvard, Yale, Notre Dame, people want to boycott Baker and McKenzie. And you say, do you feel better that there was no violation of the Civil Rights Act of 1964, Title VII? The answer is, of course, no. Never underestimate the power of reputation in cases of this sort.
Let me get one more question in, and then we'll turn it over to the audience. And a question that came up in my class yesterday. Take us through how you think about the cases of the bakers and the florists. Let's just use a baker who, I think in Oregon, a Christian baker doesn't want to bake a wedding cake for a same-sex couple. Take us through that. How do you think through that scenario? What legal or remedies do you want to see or not see?
You start.
I think if we start with the baker, the florist, people essentially running retail businesses. Well, just to start to get the ground clear, in half of the country, it's perfectly legal for them to refuse to serve a same-sex couple or a gay person because there's no national law against sexual orientation discrimination, and about half the states don't have them. So you start with looking at a complex landscape. It sort of depends on where you are. I think that to me, the assertion that I should be able in a retail business, let me go back and frame this. You know, Richard started his derivation of civil rights laws from Roman law and the notion that civil rights laws or non-discrimination laws are appropriate in monopolies. There's a second American tradition, though, that starts in the middle of the 19th century of essentially saying if you're running a retail business and somebody comes in and they can pay the freight, you have to serve them. It's not anywhere near as old, but it's a strong tendency, and it manifests itself interestingly around the turn of the 20th century in laws that I think of as they were kind of a response to laws that banned public accommodations discrimination based on race, and they said, no, all people are entitled to equal access to public accommodations to places of public amusement. They were kind of all people are equal set of laws that get passed at the start of the 19th century. And I think that tradition, you know, look, even in the states that don't have anti-discrimination laws, where that tradition holds, I think the answer is if you run a retail business and somebody comes in and they can pay the retail, then you have to serve them. You can't say no. From a standpoint of, but should there be a religious objection? I don't think there's a particular difference in sincerity of religiously held beliefs between the bakers and florists who don't want to provide things to same-sex weddings and the restaurateur in Piggy Park who said black people can buy at the takeout window, but they can't sit in the restaurant because I have a sincerely held religious belief that black people are the sons of Ham and that we're banished in the Old Testament. And so I think, you know, look, I don't think the state should be able to tell you who you go to a basketball game with. I don't think the state should be able to tell you who you have over to dinner. I don't think the state should be able to tell you who you socialize with. But I think if you run a retail business, the state should be able to say, if you can come in and you can pay the freight, you get to stay in. If you qualified for a job and you do it well, you get the job. And I think that is the only way we make the promise of equal protection real.
Well, I disagree.
No
the whole point of my talk was to indicate that I thought the common carrier approach was vastly superior to the you're in a competitive market. You open up your business on your terms and mine. And, you know, to put it the other way, let's just start with a single counter example. You are, in fact, an LGBT person, and somebody comes into your store, and they announce that they are members of the Ku Klux Klan, and they ask for you to bake a cake which will celebrate their superiority. Are you under a duty to serve them? Well, under this particular logic, maybe the answer is yes, maybe it's no. But in my view, the answer is always no. And the question is why? Let me put the question in the simplest way so you could see it. Let's take a real case. And this is the case of, I think it was the florist and the baker in Washington State that was litigated. And it turned out this was a fellow who had deep Christian beliefs would not make a wedding cake, but was prepared to do the following thing. One is to essentially sell you all the ingredients of a standard commodity so you could bake it yourself. Two, to do any other transaction for you as he had done for years. And three, to give you the name of somebody else who would supply the particular service in question. This is a man whom you now want to put out of business. What you're going to do is you're going to say, here is a person who has 15 other sources of supply. The number of gay couples who are not able to acquire the services they need for a wedding because there are odd Christian couples who will not supply them is 0.0% of the population. The sole damages that were alleged in this particular case were the $7.91 that you had to do to take a cab to the other person. And for this, you're prepared to tell people, we're going to recondition you, we're going to tell you that your mind is clear. I think it is just absolutely inexcusable. These people have deep beliefs. Now, the question is, how far do you go? Well, in my view, what you do is you go the whole way. If some black proprietor says, I don't want to serve white people and it's a competitive market, fine. What's going to happen? Most people value their reputations. Most people value making money out of this. So if you give it the complete situation and tell McDonald's, you're free to exclude, fill in the blanks, what they're going to do is announce a non-discrimination pledge the same day. So one of the experiments I ask you to think of is suppose we repealed the public accommodation laws as applied to competitive industries tomorrow. What would be the private response on the part of firms? And if I'm running a firm, what I would do is as follows. I would put up there a non-discrimination pledge, and then I would say to my employees, if you're one of the few people who are really uncomfortable with certain things, I'll find somebody else to cover your particular shift and make that sort of accommodation. What happens is the people who do this, like Martin Perez, are themselves bigots. What Perez announces as the head of the Civil Rights Commission is that anybody who has a religious objection doesn't know that it's a mere commercial transaction, doesn't understand the nature of his own religious beliefs. I'm going to force them to do that because I want to recondition their mind. Well, it turns out I know a little bit of Catholic theology, and you believe essentially that same-sex marriage is a sin under the Bible, then you're engaged in complicity if you start to advance it. But there is nothing wrong with you absenting yourself. And as was said when these cases came before the Supreme Court with the Little Sister case, it turns out we have no claim whatsoever to tell the public how it is that they should organize either their subsidies or their general rules. Just leave us alone. It was an extraordinary debate. The lawyer, two of them, Paul Clement and Noel Francisco, they go up there and say, the government form authorizes, if we want to get out of this, we have to authorize you suing our insurance company. That's complicit. And the government lawyers didn't know that it was true. They get up there and they argue in complete ignorance, and eventually they lose the case on that ground. This is a classic illustration. If you do nothing, you don't have these huge battles, these terrible fights. You don't force innocent people out of business. You don't run this. You don't say to somebody, as has been said in these cases, that if you don't wish to serve a wedding cake to somebody because of deeply held religious beliefs, you're just another Nazi in foot clothes. I can assure you, every Jew would be just fine in a world in which every bigot didn't decide to serve him, so long as they could vote, participate in public debate, open and shut their own businesses. The way you know a totalitarian society is it stops fundamental liberties the day it gets in there, and you say keine Juden as a public and political matter, not as a set of disintegrated private choices. There's no danger to competitive markets producing terrible results, and I think backing off is important. Tim Cook wants to run Apple. That's fine. The man doesn't know the first thing about running a bakery, and he should keep his mouth shut.
All right, we'll go ahead and open it up to questions.
Hi, first off, thank you so much for taking the time out of your undoubtedly busy schedules to come talk to us. I had a question pertaining to the topic of goods as distributed by natural or true monopolies.
That's all.
And I would propose that marriage licenses are part of a monopolized market. State governments have the sole authority to allow civil marriage for our states that recognize common law marriage or civil partnerships. Within your proposed system, Dr. Epstein, would gay marriage then have to be permissible at the federal level, or should states be able to determine their own marriage and civil union laws, given that homosexual couples seeking marriage could find a market in another state?
You would get exactly the right answer as a matter of political theory. That is, I am strongly opposed to an anti-discrimination law in competitive markets, and deeply opposed to any government telling voluntary arrangements that they cannot take place. So, to me, if you're just doing this as a matter of political theory, gay couples are free. Now, the interesting question is how far are they prepared to go? And so, when I prep some of the people for the same-sex debate, I said, what are you going to do about polygamy? Right? Same question I asked to you. It turns out I have the hots for 2 women, and they don't mind me sharing them, right? Big love and all of that. That conduct is criminal today under Reynolds against the United States. They confiscated the property of all the women. They sent them underground. My view is that if you protect the children of these children from these kinds of arrangements and so forth, that the same logic of freedom of association and marriage licenses ought to go. So the question I'm going to ask you, are you going to go the whole hog on this thing, or you're going to basically say, we're going to keep marriage as between 2 people, but they could be of the same sex, or we can say it could be between N people and let them decide. I can guarantee you, you're not going to see too many 7x4 marriages start to take place, but that's not a reason to ban it. That's just a reason that they don't work. So what is your response to that? Do you go the whole way on polygamy or not? I'm not talking about constitutional matter, as a moral political theory matter. May I ask why? You know, I mean, the fact that you find it offensive, you give up the game if you say that. Because then all the minority people, you know, say, oh, God, you know, all of us God-fearing Protestants and Catholics think this is offensive, so we can ban it. You've got to really face the situation. Now, historically, it's the other way. Because the so-called morals head of the police power was given an extraordinarily broad interpretation, so as to privilege certain kinds of heterosexual conduct, and same-sex marriage goes, and polygamy starts to go, and prostitution starts to go, premarital sex starts to go. Well, I think you want to narrow the morals head of the police power, which requires something of a constitutional transformation that started with Griswold in Connecticut.
A little more common ground, I think.
Hey?
One, I completely agree that people who live in polygamous relationships should not be subject to the criminal law for that. And I believe it's unconstitutional to apply the criminal law.
Now, what about giving marriage licenses?
Okay. Look, most of the constitutional rights that we recognize are rights against the government. Marriage, at least at this point, is one of the few exceptions to that, in which we say people have an entitlement to a certain kind of a recognition from the government. I'm agnostic at this moment about whether that's right or wrong, but as what I call a practicing constitutionalist, it is, and it is for sure. That's the way the Constitution stands and has stood for a very long time. In order to compel the government to issue licenses to plural marriages, you'd have to invent an entirely new structure.
Equal protection of the law.
The structure that we have doesn't answer most of the questions that are posed by plural marriages, right? If you get out, can you get out unilaterally, or do you need everybody's consent? You bring in another person, is that a one-to-one thing, or is it everybody's consent? Intestate succession, you die without a will, you divide things equally, you divide it according to time. Does the first person take? Whatever. All I'm saying is that notion that carrying your position as a constitutional matter to its logical extent requires issuing marriage licenses to plural couples, I just don't think that's right. In the rare instance of an institution where we say government has the obligation to provide, what government has the obligation to provide is not to create a whole new system of laws to accommodate that. And that certainly wasn't required to recognize same-sex marriage.
I disagree with that. This shows a complete lack of imagination.
Now, I've been accused of a lot of things, but a complete lack of imagination, never.
There have been all sorts of situations where polygamous relationships have been allowed, and I can assure you every one of those issues had to be faced. And one of the things I did do, I spent some time at BYU And I asked them, well, how did they handle it? And, the rules are, you've got 2 wives in there, you want to take a third, generally you have to get the approval of the other 2. If they come in there, you then expect to have a sharing arrangements. And the way in which it was put to me is that what happened is some of the women would specialize in taking care of the young, and others would take care of going into the workforce in order to maximize the aggregate. Then, of course, you have to deal with this delicate question of sexual access, separate kitchens, bedrooms, and so forth. They managed to do that. You put together a will. I mean, you can start to say that so much goes to the first wife, so much to the second wife. Everything that you want to do, what you first do is have it done by contract. And then what you do is you set the default sort of norms. Look, when it came to palimony, nobody said, hey, we can't possibly do this. Marvin v. Marvin, they rolled their own. We're going to enforce it. So, you take freedom of contract and apply it to religion, and you really get these kind of really jazzy, sort of wonderful results. And, in fact, what you do is you get rid of what I think to be a serious thing. And if plural marriages don't take, one way or another, we've learned something by that as well.
A little while ago, Professor Epstein said that we're both good at not answering questions we don't want to answer, and I think that was a magnificent dodge.
I think you give the licenses and let them further out their relationships.
Move on to the next question.
All right.
Yeah, what the heck?
All right.
Oh, we got Menez is gone already.
Yes, you're right.
Question? Sure, go ahead.
Give him a microphone.
Let me bring the microphone back to you.
This guy's a smoothie.
This is a question for Professor Epstein. I just wanted to address this concept of the market forces taking care of this problem. When you have a market, of course, we know that the way the market is optimized is where one actor cannot be made better off with the other actor, without another actor being made worse off.
That's competitive equilibrium.
And but that's not the same as equality. You can be optimal without being equal. And so if you do have this constitutional mandate in which states cannot deny equality, how do you address that gap without anti-discrimination laws?
Well, what you have to do is to ask equality of what? And equal protection of laws, as far as I can tell, deals with the protection of all individuals to have capacity to enter into certain kinds of civil transactions, contract wills, and so forth. Probably better found under the privileges or immunities clause than equal protection, but either way. If you go back and you read the great cases by the libertarian judges, I would suggest the one to start with, widely discredited, precisely because it's so sound, is a case called Coppedge v. Kansas, decided in 1915. And what the decision stands for is if you have a free interplay of voluntary forces without state constraints, you will see 2 phenomena. Each particular transaction will generate a Pareto improvement for the 2 parties to it. You don't enter into losing transaction. Each of these transactions will give greater opportunities for other people so that the externalities in the first instance were positive. So that's good. And the third feature is there is no way that when you run a voluntary market through successive transactions of this sort, that you will have an equality of wealth at the end of the thing. You can have Pareto improvements with disparity. And then the question is, how does a classical liberal respond to that, which I think is your other thing. One of the widely forgotten notions of modern political discourse in an age of state distribution is the one that Justice Story made very popular in the 1830s and so forth, from an early tradition called imperfect obligation. So essentially what happened is through charities, social groups, conscience, or whatever, there was a transmission mechanism to either charitable work or aid to the poor. If you actually go look at the end of the 19th century, when the material wealth is much less than it is today, and you ask yourself about the level of charitable activities, they're extremely large. You start thinking about the names of Rockefeller, the hospitals, the universities, and so forth. All of these were done under that particular model. So their view was allow voluntary exchange as a legal matter, control monopoly, open access to infrastructure, and then on the redistribution side, try to rely on this stuff. And it wasn't as though it was a trickle. It was a fairly vast situation. So nobody would say that it would be a veto on a voluntary transaction, that it made both people better off by different proportions. And your concern could lead to the suppression of that voluntary transaction, because one goes from 10 to 20 and the other goes from 10 to 3, or 10 to 13 rather. And you don't want to put yourself into the position where you're going to kill 13 units a game because you'd like to have it 15-15, which turns out to be unattainable.
Well, I'm no economist, and I just say this, that like Mr. Justice Holmes, I do not believe that the federal Constitution enacts Mr. Herbert Spencer's social statistics, which is to say...
Statics.
Okay. Which is to say that I don't think the concept of free market is embedded in the Constitution. I think people underplay the extent to which the creation of markets and the ability to work were a central informing notion of the adoption of the original Constitution. But that's a far cry from saying that the Constitution essentially imposes them. I think in the end, we just keep coming back to the real central point of the disagreement, which is my sense that the problem, better though it may be, is much more widespread and much more damaging to people at retail than Richard thinks it is, and that's why he believes markets will correct it and I don't.
Well, go back to the Holmes quotation.
I knew I'd get in trouble with that.
I mean, this man is so hopelessly confused that it's painful.
Me or him?
Him!
Oh.
What he does is, in effect, you talk about Mr. Herbert Spencer's social statics, and that makes it sound much more mysterious than it was. But the traditional origin was as follows. In the late 19th century, when you got through substantive due process, which becomes the basis in more modern times for privacy rights and abortion rights, you don't want to just dismiss it. The 19th century solution was that voluntary creation of mutual exchange is to the good, and if the state wants to suppress it, it has to show a health reason. So if you go back to Lochner in New York, this was a case in which they imposed basically a 10-hour limitation on the work week for people. Per day, right? No, 10 hours a day, 60 hours a week, you're right. Well, if it turns out, why are they doing this? What you have to do is read the New York Times of May 1905 when it comes out. And they treat this as a victory of free man over labor monopolization. This was a smarter times than we have today. Why is that? Because essentially this is a criminal prosecution of immigrant bakers who work 16-hour days, 7 of which they were sleeping. And how do we know that? Well, you just look at the statute in Section 9, and it talks about adequate ventilation in sleeping quarters, a provision that was unquestionably upheld under the health head of the police power in that particular time, even though it was probably a phone. And so what you were doing is having non-union bakers being put out of business by union bakers who work 2 separate shifts, one to bake the bread and another one in the morning to do it. There was no protection of health whatsoever in this particular case. If you look to what most people say, myself included, health is always a legitimate justification, but it can often be a pretext for anti-competitive situations. Justice, let me give you 2 other cases, one of which you will like and the other not, but they're both from 208 U.S. One of them is Mueller against Oregon, in which they decided to protect women by having maximum hours laws, and they certainly protected them. Every one of them who was protected was fired under the circumstances, and Chinese workers were hired in their place. So protection was there, and sex-specific maximum hour laws are per se unconstitutional today. They were thought to be social advancement in 2008. Why? Because Louis Brandeis, on this issue a complete illiterate, wrote a completely useless brief explaining why these statutes should be allowed. And the other case was Adair against the United States, decided by Justice Harlan, who dissented in the Baker case. And he said collective bargaining agreements in the federal rails are essentially monopolistic practices. I'm going to strike them down. So he was right. And in fact, one of the things that you can show quite conclusively is you try to track the improvement of wages in a world in which mandatory unions were unconstitutional. It's a huge burst in overall productivity. I'll mention to you one book which you ought to read, written by a lefty, so I gotta trust it, named Robert Gordon. He says if you're trying to figure out the period of maximum human improvement in welfare in the United States, it's 1870 to 1940, hands down, and he's correct. Oh, what is that era? That's the Lochner era, 1870 to 1940. They must be doing something right. And the things they did wrong were Mueller, but the important things they did right was they made sure they put a check on union monopolies and on business monopolies as well. Because the same guys that supported competition were deeply they were strong enforcers of the antitrust laws against horizontal arrangement. This was a great intellectual achievement by the classical liberals, completely understood, wrongly understood rather, by too many of the modernists.
One more question, and we'll let Professor Cole start.
I could start an answer without a question, if that's what
We know that. But somebody, come on, ask him a question. Good.
So not to start the polygamy debate again, but also to start the polygamy debate again. When Professor Macedo came last year to talk about the defense of gay marriage, his argument against polygamy was that historically it has always been discriminatory towards women. Does that argument hold any weight, either philosophically or legally at all?
I have my views.
I think that's historically correct. Whether that's a reason to make it a crime, seems to me that the answer to that is no, that it isn't intrinsically, I believe, intrinsically discriminatory, so I don't think that's a justification for a reason to make it a crime. And I think in that instance, individual rights ought to take precedence over making it a crime. But I come back to where I did on the licensing issue. I think that's just a whole different kettle of fish.
Okay, on the licensing issue, there are many people who say just get rid of all marriage licenses, at which point this problem disappears. On the question, it turns out survival rates in the systems you didn't get the 21 or the 50-50 distribution. Oftentimes it would be a plurality of women. If you don't have polygamy, then it's going to be excess females, going to be single and wandering the streets. Putting it in these kinds of relationships would be fine. Then, in effect, it's not as though any woman is duty-bound because Brigham Young says, I'd like to have you as my 73rd wife to accept that offer. And you would expect many to decline. Gary Becker actually wrote a nice piece of history on this. And he says, look, what happens is as women's opportunities in the workplace start to increase, their need to go into a marriage as the third wife starts to reduce. And you would predict the decline in the rate of polygamy as a function of greater opportunities in the market. That clearly is true. And so once you do that, the discriminatory stuff, which was very shaky back in 1900, becomes wrong today. My prediction is if you allow this, is it will be a relatively infrequent occurrence. So I'm going to ask you the question. Are you hiring a guy who's already married and think yourselves to be really limited by the fact that you can't hook on as a second wife? And I think most women today, particularly at the university level, would say no. So the difference between gay marriage and polygamy is there are a lot of takers on the gay marriage side. There are not going to be a lot of takers on the other side. But the worst reason for banning a practice is that nobody wants to engage in. And on that note,
would you like to respond?
no, he agrees.
No, most of what he said, or a lot of what he said, I do agree with. I guess I'd leave with this. If you're attracted to the notion that markets left alone really will restore equality, then before you commit intellectually, try to get familiar with being black, being a person with a disability, or being a woman at a retail level in society before you make that commitment.
And my view is always look for barriers to entry when you see systematic imbalances.
With that, thank you so much for